Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. It is said, and I tend to agree with it, that power corrupts and absolute power corrupts absolutely. And we have seen examples of that throughout history. Every time there has been a dictator or somebody who has been at the head of the government, and it doesn't matter what kind of government it is, they tend to use and abuse their power. In fact, many people enter into the political life solely for the purpose of gaining power, which they can then use. That is a flaw in humankind. It's just that humans are weak, and because we are weak and sinful, we do bad things. And many times we actually enjoy doing bad things. I have a case today that is up at the Supreme Court. In fact, today I'm recording this on March 20th. I believe that they are actually going to argue the case today at the Supreme Court. It's called Gonzalez versus Trevino. As we have spoken about before, one of the things that happens when you file a lawsuit is sometimes you get rulings that go against you, and you appeal those, usually up to the circuit court in federal court, the Circuit Court of Appeals. And then from there, if you still require justice, you go to the Supreme Court. This is a petition for a writ of certiorari by Sylvia Gonzalez, who is a former city council person in the city of Castle Hills, Texas. And it's on petition for a writ of certiorari to the Fifth Circuit. In other words, asking the Supreme Court to ask the Fifth Circuit to send up the record. And this is an immunity claim. And this is what the questions presented are. In Neves versus Bartlett, this court held that probable cause does not bar a retaliatory arrest claim against a police officer when a plaintiff shows that he was arrested when otherwise similarly situated individuals not engaged in the same sort of protected speech had not been. The circuits admittedly disagree on whether specific examples of non-arrests or any objective proof of retaliatory treatment can satisfy this standard. Here, a 72-year-old councilwoman organized a petition criticizing a city manager and unwittingly placed it in her binder during a council meeting. 2 months later, respondents, the city manager's allies, engineered her arrest for tampering with a government record. That charge has no precedent involving similar conduct, was supported by an affidavit based on the councilwoman's viewpoints, and skirted ordinary procedures to ensure her jailing. The councilwoman sued respondents, but no arresting officer. The questions presented are whether Neves' probable cause exception can be satisfied by objective evidence other than specific examples of arrests that never happened, and two, whether Neves' probable cause rule is limited to individual claims against arresting officers for split-second arrests. So, Sylvia Gonzalez is the plaintiff, and the respondents were Edward Trevino, John Siemens, and Alexander Wright in their individual capacities, and the defendant of City Castle Hills was a city defendant in the district court and is not a party to the respondent's interlocutory appeal. So, here are the related proceedings. Now, let's get to what actually happened in all of this. Now, there is a lot of law that precedes this portion of the petition, but here we're going to talk about the facts of the case. She organized a petition to criticize the city manager, and she won her council seat in part on criticizing the council manager, or the city manager. And as a result, she came to a city council meeting and inadvertently put the petition, after it had been served on the mayor, inadvertently picked up the petition and put it in her binder. Now, you could say that she inadvertently picked it up, and you could also believe, as I do, that someone, when she wasn't looking, slipped it back into her binder to trump up these charges. I don't know that for sure. That's just my second guessing of what goes on in small-minded towns. So what's really egregious here is the mayor came up and says, "Where's the petition?" Gonzalez says, "Don't you have it? It was turned in to you yesterday." At the mayor's prompting, okay, there's a clue, Gonzalez looked for the petition in her binder and, to her surprise, found it there. Gonzalez then handed the petition to the mayor, who volunteered to Gonzalez that she probably picked it up by mistake. Yeah, right. To punish Gonzalez for organizing the petition that criticized their ally, the city manager respondents then engineered a plan to arrest her and remove her from office. Under Texas law, if a council member is convicted of a misdemeanor involving official misconduct, she is immediately removable from office. The investigation of this briefly misplaced document lasted almost 2 months, and it was done first by a rank-and-file officer and then later a special detective. And he filed an arrest affidavit asserting that Gonzalez committed a Class A misdemeanor by intentionally destroying, concealing, removing, or otherwise impairing the verity, legibility, or availability of a government record. And that's Texas Penal Code 3710A3. Despite speech being completely irrelevant to the elements of the criminal offense, the affidavit listed Gonzalez's viewpoints to justify her arrest, including that from the very first meeting in May of 2019, Gonzalez has been openly antagonistic to the city manager, wanting desperately to get him fired. Part of her plan to oust the city manager involved collecting signature on several petitions. Gonzalez had personally gone to a resident's home to get her signature on one of the petitions under false pretenses by misleading her and telling her several fabrications regarding the city manager. So that's from the arrest affidavit. To secure Gonzalez's arrest and ensure she spent time in jail, the special detective performed 3 unusual maneuvers. First, instead of obtaining a summons, a standard procedure for non-violent misdemeanors, especially those involving elected officials, he chose to obtain a warrant. Second, instead of involving the district attorney, he walked this warrant directly to a judge, again, a procedure reserved for emergencies or violent felonies. Third, because he walked the warrant to a judge, the warrant wasn't in the satellite booking system, so Gonzalez could not be booked, processed, and released without jail time. Gonzalez turned herself in as soon as she learned of the warrant. Thanks to respondents' maneuvering, she spent a day in jail, handcuffed on a cold metal bench, wearing an orange jail shirt and avoiding the restroom, which had no doors. Now, because the district attorney dropped the charges as soon as he learned of them, okay, there's another clue. Gonzalez was not convicted of the misdemeanor, as a result, was not immediately removed from office. However, at least that's what they had planned, but they still succeeded in their goal. Gonzalez was so hurt by the experience and so embarrassed by the media coverage of her arrest that she gave up her council seat and swore off organizing petitions or criticizing her government. So then we get to the procedural history. She sued the respondents in the District Court of the Western District of Texas. In her complaint, she alleged that a review of the felony and misdemeanor data from Bexar County over the past decade made it clear that the tampering statute had never been used to charge someone for a common and uneventful offense of putting a piece of paper in the wrong pile. Out of 215 grand jury felony indictments obtained under the tampering statute, not one had an allegation even remotely resembling the one mounted against Gonzalez. By far the largest portion of the indictments involved accusations of either using or making fake government identification documents. So again, she wasn't exactly Charles Ponzi here, cooking up a terrible scheme. Respondents filed a motion to dismiss for failure to state a claim. The district court denied the motion, and it went from there. With regard to the respondents, the court held that the Neves exception applied, and plaintiff did not need to plead or prove the absence of probable cause. With regard to the city, the district court held that Gonzalez adequately pled that the city council, as a final policymaker, engaged in a persistent and widespread practice that was the moving force behind the denial of constitutional rights. Because the motion to dismiss was in a qualified immunity posture, respondents filed an interlocutory appeal. The claim against the city was stayed pending the resolution of this petition, and the Fifth Circuit, over the dissent of Judge Oldham, reversed the district court's judgment, holding that Neve's probable cause rule barred Gonzalez's retaliation claim. The panel majority determined that Gonzalez failed to present sufficient evidence to satisfy the jaywalking exception. In its view, Neves requires comparative evidence because it requires objective evidence of otherwise similarly situated individuals who engaged in the same criminal conduct but were not arrested. Since Gonzalez did not point to a specific individual who both misplaced a document without engaging in protected speech and was not arrested under the statute, the evidence Gonzalez provides here comes up short. Now, I'm sorry, but that's a dumb ruling. The Fifth Circuit should really be better than that. The Fifth Circuit, which sits in Texas and Louisiana and understands the theory of government corruption, I think they should have done better than that. Now, here's some of the law that governs on this issue for this particular claim. Neves versus Bartlett, which governs First Amendment claims for retaliatory arrests, was decided by this court only 4 terms ago, yet the circuits are already in an admitted split over the reach of one of its most important holdings, that probable cause does not bar First Amendment claims against police officers when a plaintiff presents objective evidence that he was arrested when otherwise similarly situated individuals not engaged in the same sort of protected speech had not been. The Seventh and Ninth Circuits have interpreted this rule to allow plaintiffs flexibility in the types of objective evidence that can make that showing. Unlike the Fifth Circuit, they do not limit plaintiffs to a narrow category of evidence consisting only of specific cases of non-arrests where people committed the same violation but did not engage in protected speech. Rather, a plaintiff can prevail by pointing to statements from arresting officers or other police officials and a wide range of other objective evidence of retaliation. While recognizing that at least one of its sister circuits has taken a broader view of the Neves exception, the court held that a specific example of non-arrests is required to invoke it. As a result, the court did not adopt the other circuit's more lax reading of the exception and denied petitioner Sylvia Gonzalez her claim for retaliatory arrest over dissents by Judge Oldham and later by Judge James Ho. By breaking with the Seventh and Ninth Circuits, the court blinded itself to clear and objective evidence of retaliatory motive presented by Gonzalez in her complaint. For example, Gonzalez was arrested for the routine and common mistake of misplacing a document, a petition she organized by inadvertently putting it in her binder. But in the last 10 years, the statute used for her arrest was never once used to jail someone engaged in a remotely similar act. Gonzalez's arrest was also inconsistent with the regular practice in Bexar County, where jails are overcrowded and nonviolent misdemeanants with no criminal records are processed without being jailed. Finally, the arrest affidavit listed Gonzalez's viewpoints as relevant facts warranting her arrest. The court below acknowledged that the complaint revealed virtually everyone prosecuted under the statute was prosecuted for conduct different from hers, but it held that because of the plain language of Neves requires comparative evidence of non-arrests, Gonzalez's failure to point to records of people who misplaced government papers without criticizing the government and were not arrested for it meant that she did not satisfy the Neves exception. And the court did that because it made a dumb decision. Tellingly, the court stated that if we were writing on a blank slate, we might well agree with Judge Oldham's dissenting view of the exception, especially because Gonzalez's arrest was allegedly in response to her exercise of her right to petition. But the majority felt bound by the better reading of the relevant Supreme Court precedent. Pah! Hogwash. That's just nonsense. So it is now up at the Supreme Court and will be argued today. Now, it always amazes me how defendants react to very well-crafted petitions for certiorari or even appellate briefs. Usually, the tactic is to throw as much garbage up against the wall as possible to essentially say, look, squirrel, over there. No, underneath the table. Look, no, up on the ceiling. That's the whole trick. You want to distract the court from what's really at issue here. And what's really at issue is this woman was thrown in jail. A 72-year-old woman was thrown in the Bexar County Jail with all kinds of felons and misdemeanors solely because she wanted to get the city manager of Castle Hills, Texas, fired. Now, you can believe that she was right in that, or you can believe that she was wrong in that, but even if she was wrong, even if the guy didn't deserve to be fired, she absolutely had a First Amendment right to argue for that outcome. And the idea that she would not be granted the right to sue on that when it's very clearly evidentiary in terms of retaliation is absolutely mind-boggling. But let's take a look at what the city and its minions say about this particular claim. Counterstatement of questions presented. Neves versus Bartlett involves a warrantless arrest by officers allegedly in violation of Mr. Bartlett's protected speech rights under the First Amendment. The court discussed the narrow qualification to the long-standing principle that the existence of probable cause defeats a retaliatory arrest claim where individuals are not ordinarily arrested for a particular crime. Ultimately, the court determined that Bartlett's claims could not proceed against the officers because the officers had probable cause to arrest him. Petitioner invites the court to apply this narrow qualification to arrests pursuant to a warrant issued by a Texas state district judge. Petitioner's argument would virtually eliminate qualified immunity for arrests pursuant to warrants when a plaintiff pleads unsupported allegations of retaliation. Now, notice how they threw in unsupported allegations when right in the arrest affidavit it mentions her viewpoints. This is not a good look. You know, my boss used to tell us when we argued before the court, you need to get caught telling the truth at least 3 times to have credibility. He already suffers, these folks already suffer from strike 1. Petitioner's argument would nullify the independent intermediary doctrine which encourages officers to seek a warrant. That doctrine states it is well settled that if facts supporting an arrest are placed before an independent intermediary, such as a magistrate or grand jury, the intermediary's decision breaks the chain of causation for false arrest, insulating the initiating party. Under this doctrine, even an officer who acted with malice will not be liable if the facts supporting the warrant or indictment are put before an impartial intermediary, such as a magistrate or grand jury, for that intermediary's independent decision breaks the causal chain and insulates the initiating party. Now, that's just the lead up to what they say the questions are. Does the similarly situated provision mentioned in Neves refer to persons who committed the same criminal conduct? Does the narrow qualification mentioned in Neves abrogate qualified immunity where a judge makes an independent determination of probable cause and issues a warrant prior to an arrest and in the absence of allegations of taint or Franks or Malley exceptions to the independent intermediary doctrine? Well, Here is the problem with that. The problem is they are claiming that the magistrate is doing an independent evaluation. But of course, that's wrong because the magistrate is relying entirely on the truth of the affidavit. And in that regard, he isn't making an independent evaluation. What he's doing is he's saying, okay, if these facts are as you say they are, then there's probable cause. But if you, and what's really amazing about this is that the judge simply must not have read through the entire arrest affidavit. Because if he had, he would have looked and he would have seen the, what I would call viewpoint issues in the affidavit, and on that basis has said, this is coming really close to a First Amendment violation. Why don't you go back and think about this? And that's what I don't understand. Either the judge, for whatever reason, didn't read all the way through the affidavit or didn't understand what was actually being done here. For whatever reason, there was absolutely no reason for him to grant this warrant. And when the district attorney got it and looked at it, he threw it out immediately. So it looks to me like where you go past the district attorney, which is normally a second safety measure here. First, you've got the sworn duty of the law enforcement officer. That's your safeguard. Then you have the sworn duty of the district attorney to evaluate on the basis of the facts pleaded whether or not there has actually been a crime committed. And then the third stop on the train is the judge, and the judge has to make a determination based on what's contained in the affidavit. So if the district attorney moved immediately to dismiss the charges, it seems to me that there is a presumption here that this was, from the get-go, a false arrest. So the Supreme Court is doing the oral argument on Wednesday, March 20th, and I suspect that there will be some audio released shortly from that oral argument. And if at all possible, I will try to follow up on this case after that audio is released. That's what I have for you today. Thank you so much for watching. If you have any questions, leave them in the comments down below. Like, share, subscribe, all that stuff we ask you to do. You can email me, particularly if you have a video request. Just make sure you put video request in the subject so I know. And if you have the opportunity today, do something nice for somebody. It never hurts to help other people out and do something good for them. It makes the world a better place. And then when you're done, come back here and catch me down at the beach again next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.